until his appointment as city prosecutor of Mandaluyong in 2002 at the age of 39. And then in 2010, he was given a prestigious award, the Ulinang Mandaluyong, and this award acknowledged his impressive skills or impressive career in public service, showcasing his commitment to para mag-serve sa community. And then, before his appointment sa Supreme Court or High Court, nag-serve muna siya as Associate Justice of the Court of Appeals for 11 years. And then, noong August 6, 2019, he was appointed by the former President Rodrigo Roa Duterte as the Associate Justice of the Supreme Court naman. Replacing Associate Justice Mariano del Castillo na nag-retire noong July 29, 2019. And thus, he is the first Supreme Court appointee to take a decision writing exam in addition to the interview conducted by the JPC or Judicial Bar Council. And ang ibig sabihin doon, he had to take a decision writing exam para to demonstrate his skill in his ability to write well-reasoned or legally sound judicial decision. Kasi typically, when someone is nominated sa Supreme Court position, they are interviewed by JBC Council, JBC. Tapos, yung JBC, i-evaluate nila yung qualifications and then mag-recommend sila ng candidate sa president. Pero siya, in Justice Talaveda's case, ay nag-take siya ng decision writing exam para sa addition sa JBC interview.
So good morning everyone, I'm Johnson Ibarres. Today I'll be discussing the first 10 case, notable reinforcement contributions to the judiciary. And the notable is cases of Justice Salameda. So for the first 10 case of Justice Salameda, specifically the GR number 23416, dated February 19, 2020, wherein first the case of People of the Philippines versus XXXX. Now, the accused was convicted for the crimes of violating the Republic Act 1853 or the Anti-Rape Law, and the Republic Act 7610 or the Special Protection of Children Against Child Abuse, Exploitation, and Discrimination Act. Now, ang nangyari is the private complainant or CAAA and her sister were 7 years old pa lang yung sister niya, 13 years old na ang private complainant, in-invite ng kanyang tito sa kanilang bahay para doon tumira because nag-promise si tito or si accused na papaaralin sila. Ngayon, yung una, mabait naman yung pagkikito niya, pero not nearly a week after, sinimulan niya ng sexually abuse ang ating private complainants. Wherein nag-continue ito for 8 months. That, ang makahuli pa is yung sariling anak ng accused na 18 years old at that time, and pinataan niya yung kanyang gustong anak na papatayin niya ito in pagsusubok siya. Then, yung ginawa ng kanyang anak, siyempre, disposa, is sinabi niya sa kanilang mga pinsan na nakarating naman sa mga pinsan-pinsan hanggang nakarating sa nanay ng private complainant, wherein siya mismo ang kumuha sa kanyang mga anak sa kanyang ito. Ngayon, both the RTC and the Court of Appeals found the accused guilty beyond reasonable doubt for the crimes of violating the Republic Act 8353 and Republic Act 7610. Wherein hereby, he was sentenced to suffer reclusion perpetua for both cases. Now, the accused appellant is inakyat niya sa Supreme Court the issue of whether or not the trial court greatly erred in convicting the accused appellant of the crime charged despite the highly incredible and inconsistent testimony of the private complainant. The reason behind this is sabi ng accused appellant na the RTC and the Court of Appeals calls for giving the credence to AAA's testimony contending that there were discrepancies between AAA's sinumpang salaysay and testimony, and that her testimony itself for inconsistencies and absurdities. He points to the discrepancies given by AAA about the details of their residence at the time, the first incident, the site of the second incident, and the exact number of times he was allegedly molested her. Now, the Supreme Court ruled that no, the court finds that when a woman, especially a minor, alleges rape, she says in effect all that is necessary to mean that she has been raped. And further, pag mas bata ka kasi or you are a minor, the case of the private complainant is mas honest and sincere ka sa mga sinasabi mo. Kaya, a young girl's revelation that she has been raped, coupled with her voluntary submission to medical examination and willingness to undergo public trial, where she could be compelled to give out the details of an assault on her dignity cannot be so easily dismissed as a mere fabrication. Moreover, the credibility of the private complainant is unaffected by trivial inconsistencies and discrepancies in her sinumpang salaysay testimony. Wherefore, the Supreme Court finds the accused complainant guilty beyond reasonable doubt for the crimes of violating the Republic Act 8353 and Republic Act 7610, wherein the Supreme Court modified the sentence of the RTC and the CA kung saan i-accuse for the crimes of violating the 8353 is hereby ay na sentence siya to suffer reclusion perpetua, and sa Republic Act 7610 is the Supreme Court sentenced to hereby suffer reclusion temporal. For the notable reforms and contributions in the judiciary of Justice Alameda is the introduction of new members and installation of officers and fellowship type. Justice Alameda advises Capiz lawyers that the use of technology, cautiously and responsibly. Justice Alameda noted that the responsible use of social media is perhaps the most important technology related contribution in the CPRA, or the Code of Professional Responsibility and Accountability. And Justice Alameda further emphasizes that while freedom of speech is one of the most precious rights, it comes with limitations. And especially for lawyers or officers of the court, with the responsibility and accountability. Now, for the notable cases of Justice Alameda is, dito sa first notable case ni Justice Alameda is, may confusion na nangyari between Mr. Conesio sa Lugban kasi nakita niya daw sa lobby na si Chief Justice Esmundo daw yung nagpunente, pero nakita ko naman sa mismong website ng Supreme Court na si Justice Alameda. Pero, I just expand yung sinabi ni Mr. Conesio sa kanya. Now, Justice Alameda penned the case of GR number 254753, dated July 4, 2023, where it penned the case of Sigrid Duro versus Major General Eric Sigonoya in his capacity as commanding officer of the 13th Division. Ayon, si Duro is an activist sa Iloilo and the founder and vice president ng Bayan Muna Party List and Makabayan Coalition. Ngayon, si Major General Eric Sigonoya is nagpakalat ng poster sa buong Iloilo City with the picture of the petitioner and a quote that says, "Disciples of CPP and ANTF in the city, fooling everyone, fooling and deceiving the people, holding rallies here and there, they have done nothing for the country." Now, yung pagre-red tag sa ating petitioner is nag-continue for months until nag-file siya ng petition for writ of amparo. Now, I not din naman na siguro i-explain pa kung anong writ of amparo because sinabi na ni Sir last meeting. But, the RTC immediately dismiss yung writ of amparo or yung petition ng petitioner. Meaning, wala nang nangyari yung amparo. basta right to life, liberty, and security. Kung nararamdaman mo na binabiolate ito ng mga officials or government officials, hindi lang government officials pati na rin military officers, is pwede kang mag-file ng writ of amparo. Ayun, katulad niya nagsabi ko, the RTC immediately dismiss the petition, meaning walang nangyaring trial. Hindi man lang pinag-statement si petitioner kung bakit siya nag-file ng writ of amparo. Ngayon, inakyat nila sa Supreme Court with the issue of whether or not the Court of Puo seriously erred in dismissing the petition outright without requiring the respondent to file a return or even conducting a hearing. Now, ang ruling ng Supreme Court is yes. Petition filed before the RTC is thus neither manifestly groundless nor lacking merit. It was error for the RTC to cursorily dismiss the case without requiring the respondent to file a return. The RTC effectively denied both parties due process. It's not only prevented the petitioner from fully ventilating his cause, but it also deprived the state occasion to effectively define in its side of the matter. Now, the Supreme Court further emphasizes that red tagging, vilification, and labeling, and guilt by association threaten a person's right to life, liberty, and security, which may justify the issuance of writ of amparo. Ngayon, pinabalik nila ulit sa RTC yung case para i-review ng RTC and ma-file yung writ of amparo na kanyang nire-refuse. And for the second notable case of Mr. Salameda, specifically the GR number 251954, dated June 10, 2020, where he penned the case of inmates Raimundo Reyes and Vicente P. Evangelista versus Bucor Chief Gerald Banta. Ngayon, both the inmates are represented by Attorney Ruby Rossi Cagasca Evangelista, asawa ni Vincent P. Evangelista, which are an inmate. Ngayon, both the inmates were convicted for the crime of violating the Republic Act 6425 or the Dangerous Drugs Act of 1972. Kasi nahuli silang nagbebenta ng shabu, and nahulihan din sila ng 974.12 grams of shabu. Ngayon, both of them were hereby sentenced to suffer reclusion perpetua under this law. Ngayon, Attorney Cagasca Evangelista claims that Reyes and Evangelista have already served 19 years and 2 months or more than 18 years the benefit of good conduct time allowance. Now, ang good conduct time allowance is magbabawas ng sentence ng isang inmate because good yung behavior na sa loob ng binibid. And under Republic Act 1592 was to be considered with the benefit of the GCTA, which may be applied retroactively. Reyes and Evangelista already served more than the required sentence imposed by law. And ang issue dito sa case na to is whether or not Reyes and Evangelista be discharged of imprisonment. Now, ang ruling ng court is no. They further emphasize this doctrine. Under the Section 2, Rule 4 of the 2019 revised IRR of the Republic Act number 10592, as amended provides that the following shall not be entitled to any GCTA during serving of sentence. First, recidivists, habitual delinquents, escapees, and PDL convicted of heinous crimes. In this case, both Reyes and Evangelista were found guilty of illegal sale of dangerous drugs exceeding 200 grams na can be considered as a heinous crime. And ang basis nila dito kung bakit siya heinous crime is the Republic Act 7659, which includes the distribution or sale of dangerous drugs as heinous for being grievous, odious, and hateful offense, in which by reason of its inherent manifest wickedness, viciousness and atrocity and perversity is repugnant and outrageous to the common standards and norms to the decency and morality in a just, civilized, and ordered society. Now, let's move on sa self-justice.
The next is the second cousin, Justice Mario Villamor Lopez. He was born on June 4, 1955 at La Union, Luzon, Philippines. Educational background: graduated cum laude from San Beda College with a law degree. Later earned a Master of Laws from the University of Santo Tomas. He placed among the top 30 examinees in the 1980 bar exam with an average of 85.5%. Good morning, everyone. My name is Luana Williamson, and I will be discussing the career background of Justice Mario Lopez. So he started his career as a technical assistant at the Supreme Court, and later on, after 3 years, he held a role at the Central Bank of the Philippines as a hearing officer. And in 1994, he was appointed as an RTC judge in the Batangas City and also awarded as the most outstanding RTC judge of the Philippines in 2005. Aside from being a judge, he is also a professor in the San Beda College, UP Diliman, and Arellano University, and also awarded twice as the most outstanding professor of the Philippines. And he also lectured internationally and mostly represented the Philippines in the legal organization. And on December 5, 2019, President Rodrigo Duterte appointed him as the Associate Justice of the Supreme Court. Prior to this, he is 13 years. He served 13 years as Associate Justice of the Court of Appeals. That's me. Good morning, everyone. I'm Jimmy Ramos, and I will be presenting the notable reforms, contributions of the judiciary, the first one is notable case. So, sa notable reforms, contribution to the judiciary, Justice Lopez promotes ethical standards. He has been actively involved in promoting the code of professional responsibility and accountability, or CPRA as the new lawyer's code. So ang ano niya dito is, these initiatives aim to instill a greater sense of ethical responsibility among lawyers, leading to a more trustworthy and accountable legal professions. The second one is the legal education reforms. Justice Lopez has been instrumental in advocating for reforms in legal education. These reforms is to improve law school courses and pedagogy. Clinical education program to provide law students with practical knowledge, skills, and values in delivering the services. So the first case by Justice Lopez is the People of the Philippines versus PBB under the number of PR 247234 on August 22, 2022. So the accused was convicted in lower court for sexual assault against his niece and nephew. Then on the second day of July 2010 in province of Bukidnon, Philippines, the accused is taking advantage of one KKK, a 3-year-old minor born on June 13, 2008, did then and there willfully, unlawfully, and feloniously grab and insert his finger into the private part of KKK, thereby demeaning, debasing, and degrading the intrinsic worth and dignity of the latter as a child, and also that on or before the 16th day of November 2011 at the province of Bukidnon, Philippines, the accused, prompted by new design, did then and there willfully, unlawfully, which was he treated the children like his own and never alone with them, plus the witnesses of the accused stating how loving and caring and kind the accused is, there is a medical examination from Dr. Marcela Orong or Dr. Orong, the rural health physician, who examined the two minor KKK and LLL, attested that the medical certificates presented in court were the ones he issued. He conveyed that the examination he performed on KKK revealed that she had healed lacerations on a ruptured hymen, which could have been caused by any blunt object like a finger. KKK was crying when he examined her. As for LLL, Dr. Orong's examination showed that the boy had multiple red lesions in the anal area, which could have been caused by constant scratching or insertion of a blunt object. The tip of his penis was also inflamed, which could have been caused by irritation, sucking, and painfulness as a child. So the Supreme Court found that the testimonies of the victim, KKK and LLL, were credible and consistent. Medical examinations corroborated their accounts as sexual abuse. So the ruling of the Supreme Court affirmed that the decision of the Court of Appeals, which upheld the RTC's conviction of BBB for 2 counts of rape by sexual assault. The penalties imposed by the lower courts were also affirmed with modifications. The notable cases is People of the Philippines versus Willie Mendoza. So in this case, accused appellants Menard Fer and Roderick Pangal de Guzman are found guilty of murder in the case of Barangay Captain Leonidas Bulatao, with the Supreme Court upholding their conviction in the imposition of reclusion perpetua as the penalty. So ang kaso na to is about the killing of the Barangay Captain Leonidas Bulatao, and their motive in killing is due to a personal dispute that escalated into violence, and it was rooted on ongoing animosities between Bulatao and the accused, which were exacerbated by political rivalries in the community, where Willie Mendoza, Rodel de Guzman, Christian Centeno Sapiera, Rogelio Viray Iberezo, Menard Ferrer, Dexter Gramota Pimen, Bernardo Palisok, and Roderick Pangal de Guzman, armed with unlicensed firearm with intent to kill, mutually helping one another. So the defense tried to raise alibi, claiming that they were elsewhere during the time of the crime, but there were a lot of witnesses who saw the incident plus the surveillance camera. So the RTC found the accused appellants Ferrer and de Guzman along with Mendoza and Pimen guilty of murder, sentenced them to reclusion perpetua. RTC ruled that the prosecution established all elements of murder, including treachery and evident premeditation. So the Supreme Court's decision upheld the conviction of the accused for the murder of Barangay Captain Leonidas Bulatao. The court found sufficient evidence to support the lower court's findings, affirming that killing was intentional.
So the next justice that we're going to discuss is Justice Samuel H. Garland. He is born on December 19, 1958 in San Juan, La Union, and he finished his Bachelor of Laws degree from San Beda College in 1983, and he was admitted to the bar a year after. So his judicial career started on July 1, 1993, when he was appointed as municipal court judge in Bangarlang. But before we handle the judicial career of Justice Garland, let us first go dive deeper into his first career is when he didn't pass yung bar exam. So first he was a private practitioner
Wala pa pangalan ko yun.
Brokers and Dealers Incorporation, Securities
Wala pa pangalan
Investment
sila.
Protection Fund Incorporation. So, yun yung mga una niya naging trabaho before siya naging power lawyer or public authority noong 1990 hanggang 1992. So, during his judicial career, noong July 1, 1993, naging MTC judge siya sa Bangor, La Union. And then after being an MTC judge, he became an RTC judge sa San Fernando City, La Union noong May 23, 2001. And to March 2004, nag-transfer siya sa Quezon City and doon siya na-appoint as a Court of Appeals Associate Justice noong July 15 naman ito, 2009. And ayun, he served as a chairperson of the 17th Division before being appointed to the Supreme Court as the 187th Associate Justice noong January 8, 2020. And he was appointed by President Felipe Romualdez. So that is for his education and yes, for his career and educational background. So let us proceed po to the notable cases po of Justice Clarence. Next is Samuel Gerlan, Associate Justice Samuel Gerlan, notable reforms, contributions in judiciary. So in 1993,
Nasa yan?
si Justice Gerlan
Ako.
appointed as presiding judge sa MTC Bangor, La Union, or the Municipal Trial Court sa Bangor, La Union. 8 years siya doon, at nung pumasok siya is meron pang 200 pending case. And he was so proud kasi dun sa pending case na yun, marami siyang naibawas. Sabi niya pa, ayun. Tapos, throughout his career, may mga nakuha rin siyang award gaya ng, he became the most outstanding RTC Judge of La Union in 2003 and Judicial Excellence Award noong 2007 galing sa Rotary Club. And also, yun nga, di ba, naging professor siya ng law school. So, na-notice niya na ang mga students is nahihiya makapag-argue sa mga professors nila kasi nahihiya daw sila kasi baka ma-offend yung mga professors. And for him, that should not be the case. Kasi sa law school dapat nagsisimula talaga sa classroom na hindi lang kapag moot court, na kapag debate, gano'n. Kasi you are to convince the court sa stand mo. Kaya dapat ready ka kahit wala ka sa moot court. And his first pen is also the first notable. So this case talks about parricide. So parricide meaning when someone kills someone that is close to them. For example, their children, their parents, or their spouse. So in this case, People versus Florenda Manzanilla v. De Asis. Florenda was the wife and also the accused appellant. And Angel Manzanilla, which is the husband of Florenda, and which was killed. Also, si Roberto, which is the side chick or the kabet ni Florenda. So in 2007, nakita ng witness si Florenda Manzanilla at saka si Roberto with hindi nakilalang lalaki sa tabi ng kalsada. Nakita ng mga witness. And naririnig nila na ito, Angel ang pangalan ng asawa ko. Sabi niya daw ni Florenda kay Roberto. Tapos bilis-bilisan kasi baka daw may makakita, nasabihin na yariin na yan, gano'n. Tapos after 30 minutes, si Angel bumaba
siya galing, bumaba siya from the jeep. Tapos si Florenda, kasama yung hindi nakikilalang lalaki, ano siya, they were 5 to 6 meters away from dun sa, kay Roberto at saka kay Angel. Nung dumating na, yung bumaba na si Angel, yun, pinuntahan agad siya ni Roberto, tapos sinawakan niya sa balikat. Tapos nagpakilala siya, kilala mo ba ako? Ako ang kapit ng asawa niya. Ganun. Tapos pinunta niya sa madilim daw na area. Tapos doon na narinig ng mga witness yung putok ng barel. Kaya nataranta sila, so nagpanik sila, nagtago sila sa grassy area. Tapos ngayon, ang defense naman nito ni Florenda, nasa bahay nila siya. Tapos minamanage na daw yung store nila, kasama yung anak niya, saka yung ibang bata doon na naglalaro ng video games. Ngayon, during the trial naman, namatay si Roberto, kaya napinis lahat ni Florenda yung kaso. Wala kang kasama. The decision was guilty siya as a principal of inducement. Meaning, you are still liable sa kaso even though you did not do the crime yourself. Kahit ay kapag inintus mo siya or ikaw yung mastermind, liable ka pa din. Tapos hindi nila yung alibay ni Florenda kasi hindi siya consistent. Tsaka, kung kasama niya yung anak niya, bakit hindi niya pinag-testify? Yun yung tanong ng court. Kaya, ang ruling is, ang decision ng Supreme Court, dismiss yung appeal ni Florenda, and nakasulat siya ng reduction perpetuum plus damages from act indemnity. Next case, this case emphasizes
Ikat na lang nung ano.
This emphasizes that lacking sufficient evidence can exempt you from conviction. So in this case, Daniel Imperial versus People of the Philippines. Dito sa kaso na to, Daniel Imperial, siya yung head ng maintenance department ng NTC-MTC company. Tapos, na-accuse siya of stealing ng Royal Court, which cost 5,700 pesos. Ngayon, so kinasuhan siya. Tapos sabi ng RTC, di ba nga nawala? Kasi siya yung head ng maintenance department. Tapos, siya yung head ng maintenance department. Kaya siya yung responsible sa maintenance supply. Kaya sabi nila nung nawala yung na in-order ng company, ay si Imperial yan. Siya ang siya ang nagmamanage dyan sa mga ganyan, mga supply at mga wires, kaya ng Royal Court na in-order ng company. Sabi ng RTC, oo, qualified ka ng guilty ka ng qualified theft. Ni RTC. Kasi, ang basis nila, si Imperial ang nag-order ng Royal Court. Ngayon, nung dumating, ibang court yung dumating. Tapos, hindi pumayag si Imperial, sabi niya, hindi ako papayag. Kaya inakyat niya sa inappeal niya sa Court of Appeal
ng RTC, which was qualified, guilty siya ng qualified theft. Ang ano naman ng Court of Appeals, ang prosecution daw, na-prove na nila yung point nila kahit na hindi pa ganun ka-heavy yung ebidensya na siya talaga yung nagnakaw. Tapos hindi pa rin siya pumayag. Inakyat niya sa Supreme Court yung kaso. Tapos sabi niya, wala nga silang solid proof na na ako yung kumuha, hindi nga nila nakita sa akin. Ganon. Kaya nireview ng Supreme Court, nireview ng Supreme Court yung decision. Sabi niya, alam mo, tama ka. Sabi niya. Alam mo, tama ka, sabi ni ng Supreme Court. Kasi nag-base lang yung mga lower court sa mga circumstantial evidence. So ano nga ba ang circumstantial evidence? Ito yung mga evidences na hindi direct na pinuprove na ikaw yung gumawa ng isang bagay. Para lang siyang clues na kapag pinagtumbayan mo is parang ikaw yung gumawa ng krimen. Parang gano'n. Parang gano'n. Tapos, especially in criminal cases, dapat hindi gano'n. We should not base sa mga circumstantial evidence o sa mga parang oo, parang gano'n. Mga hula-hula ba, gano'n. You should always decide beyond reasonable doubt. Ngayon, ganito ang nangyari kay Imperial sa mga lower courts. Pero nung inakyat niya sa Supreme Court, and he was then acquitted. So, Imperial, inacquit siya ng Supreme Court. Also, ninote nila doon, ng prosecutor na hindi nga, yung nag-deliver nga nung royal wire is hindi direkta mismo sa kanya binigay. Nilagay lang siya dun sa vehicle na hindi naman si Imperial yung nagmamanage. So, ayun. So, ito yung, this shows the importance this shows the importance of deciding beyond reasonable